Through 27 specific constitutional clauses, the Pakistani legislature has moved to rewire the state's internal mechanics. This is a deliberate, structural shift designed to recenter power within the parliament and away from the bench. The driver for this change lies in years of institutional friction. Political parties have accumulated deep grievances over what they perceive as judicial overreach, most notably the Supreme Court's direct disqualification of sitting prime ministers. The response was swift. In late 2024 and early 2025, Parliament utilized its two-thirds majority to pass the 26th and 27th Amendments, creating a new mathematical balance between the executive, the legislature, and the judiciary. I am Zohaib Ahmed Anjum. For CSS 2027 aspirants, navigating the technicalities of these amendments is now a requirement for the current affairs exam. You should prepare to address this specific prompt. Evaluate the proposed 26th and 27th Amendments in terms of their implications for judicial independence, federalism, and democratic accountability. To master this analysis, we must look past the political rhetoric and identify exactly how these amendments pull the constitutional center of gravity toward the legislature. We will deconstruct the amendments across three vectors: the judiciary, federalism, and accountability. In a stable democratic system, these three forces exert equal tension, maintaining an equilibrium that prevents any single branch from dominating the others. The new amendments act as a weight on this system. The increase in legislative gravity pulls the center of power toward Parliament, stretching the independence of the judiciary and the autonomy of the provinces. Our task is to determine the long-term impact of this shift on the remaining corners of the triangle. We start with judicial independence. The 26th Amendment makes its most direct impact on the selection of the Chief Justice of Pakistan. Under previous rules, elevation to Chief Justice followed a predictable pipeline of strict seniority. The 26th Amendment removes this automaticity. A legislative committee now chooses from the three most senior judges, introducing political choice and imposing a 3-year term limit. The restructuring continues at the Judicial Commission level. By increasing the number of elected representatives on the commission, the amendment ensures the judiciary no longer has the final word on its own appointments. The 27th Amendment adds a new structural layer. It creates a separate body, the Federal Constitutional Court, effectively splitting the highest level of the legal system. Transferring constitutional jurisdiction to this new court moves the Supreme Court to the sidelines, functioning primarily as an appellate body for standard legal disputes. The International Commission of Jurists has signaled that these changes collectively constitute an assault on the separation of powers. Because internal judicial autonomy has been replaced by external political control, judicial independence now operates under constant structural pressure. This brings us to federalism. In a federation, constitutional courts are the final arbiters of disputes between the center and the provinces. The new Federal Constitutional Court centralizes interpretive authority. Disputes once heard by the Supreme Court are funneled to a centrally appointed body in Islamabad. It will now rule on sensitive provincial autonomy issues, including the 18th Amendment, resource allocation, and fiscal federalism. Because this court is designed through a centralized political process, analysts warn its rulings are more likely to favor the federal executive over provincial rights. There is also the issue of procedural legitimacy. These amendments were passed at extreme speed, leaving little room for public or provincial input. This lack of broad consultation violates the spirit of cooperative federalism, which requires consensus before altering the constitutional balance. By consolidating interpretive power without provincial agreement, the amendments risk weakening Pakistan's constitutional identity as a decentralized federal system. Finally, we evaluate democratic accountability. The primary defense for these reforms is built on the principle of parliamentary sovereignty. Proponents argue that parliamentary control over judicial appointments improves oversight and curbs unelected activists. However, while parliamentary power grows, horizontal accountability, the system of checks and balances, has been dismantled. A critical feature of the 27th Amendment expands legal immunities for high state offices. These immunities effectively insulate the executive from judicial review, reducing the ability of citizens to challenge abuses of power in a court of law. Ultimately, Attempts to discipline the judiciary through constitutional restructuring can erode public trust in both the courts and the parliament itself. The government presents this as a step toward democracy, but the structural evidence suggests a system where checks on executive authority have been neutralized. For a high-scoring CSS essay, your conclusion must synthesize these three vectors into a single cohesive verdict. Revisit our analytical model. On judicial independence, the bench is under structural pressure from politically controlled appointments. On federalism, the constitutional balance shifts towards centralized authority without provincial consultation. And on accountability, democratic checks are constrained by expanding executive immunity. The 26th and 27th Amendments effectively assert parliamentary dominance, but they do so by compromising the rule of law and provincial trust. For expert guidance on current affairs or to enroll in our CSS preparation sessions, contact us on WhatsApp.